I'm Hector Gutierrez. Today we're having an attorney speak to you. He is Nicholas Kritikos, specializing in real estate, uh, primarily in real estate contracts, procuring costs, disclosure issues, and he is very well experienced and is doing this for a very long time. And I'd like to introduce to you Nicholas Kritikos, and tell us something about yourself. How did you get into being an attorney right here where you are in this space in your time?
Sure thing. Well, I graduated law school in 2015 and went to uh, California Western School of Law in San Diego. And, I'm originally from the Inland Empire. So after graduating at Cal Western, I practiced there until 2022 and then moved back to the IE, where I practice now. And I started my own firm. But in San Diego and continue on to now, I practiced real estate law, dealing a lot with real estate disputes, specifically with the California Association of Realtors (RPA) form, broker to broker disputes, um, really anything having to do with the car forms. I've kind of become
Now, how did you
I've
segue?
memorized those.
How did you segue your career into specializing in this field? How did that come about?
Just kind of naturally, those were the types of disputes I, for whatever reason, was getting calls on, my entire career. And, you kind of learn by being thrown into the fire. So I slowly learned how these cases are litigated. Not just the law behind them. The law is kind of easy to learn. It's kind of the practical things you learn along the way
Mhm.
um, when getting hands-on experience on these types of disputes. Uh, you know, Off the top of my head, the biggest thing that the most kind of eye-opening thing that I learned um, had to deal with broker to broker disputes and the dispute resolution process that the California Association of Realtors has set up to handle these disputes. You don't go to court. You handle these disputes internally through their ethics complaint and arbitration process. And I've gone through that process with multiple uh, you know associations.
Right.
Every kind of every local association has its own variation on how to deal with those disputes. They're all more or less the same, but they all have their own intricacies. And that was kind of the most eye-opening thing that I learned about these broker to broker disputes, particularly.
Yeah, because even though they're under the umbrella of NAR, each individual association actually only has their own bylaws also, and that really is kind of interesting how you have to navigate that.
Yeah, and especially when you're dealing with disputes between a broker that's a
Right.
member of, the San Diego Association of Realtors, and then one that's a member of the East Valley. Like, what rules apply in those types of situations? Yeah, you deal with all of those types of issues.
It's very interesting.
And
So,
then on top of that, the MLS has its own rules
oh
that
yeah,
all the
yeah, that's a
realtors have
whole
to
nother
follow.
ball. Yeah, that's a whole
Yeah,
nother game there.
yeah.
So let's go. Let's start from the beginning. So, person writes a contract. You have a client who you think is your client. So, how do we figure, oh, how do we avoid these procuring cost issues that come up?
Well, as far as procuring cause goes, um, there's no, I don't know how to avoid them as they're happening, because a
Right.
lot of the time it has to deal with the actual client, the the buyer or the seller.
Right.
Um, the way you solve them, and that's usually when I get involved, is the best way to solve them is to go to mediation. And
Okay.
the process is uh, first you have to file the arbitration complaint, and then you have a couple of days, I think 90 days. And by the way, let me preface this all by saying none of this is legal advice. And if you need legal advice, call a lawyer. Call me, for instance.
Right.
Um, but having said that, I believe there's a 90 days from the date of the close of escrow where you have file this arbitration complaint, and then part of that process um, requires the parties go to mediation if they agree to. And having gone through that process, I think it's always better to try to resolve the dispute at mediation than go into arbitration, because the arbitrators, at least in the disputes I've been a part of, uh, and all the kind of local bylaws and guidelines I've seen, require your seasoned realtors to be the arbitrators, and these are volunteers. Typically, I don't think they get paid to do it. They're not lawyers. They're not retired judges like I
Peers, kind
usually
of.
deal with.
Yeah.
Yeah, they're your peers.
Mhm.
Yeah, exactly.
Yeah.
And usually, one party will like be buddies with, one of the
Yeah.
arbitrators,
Right.
because you're dealing with a panel of 3 arbitrators usually.
Mhm.
Uh, and yeah, you deal with these situations where when you go to arbitration, if it goes to arbitration, the law doesn't really matter.
Mhm.
It's because you're not dealing with lawyers and retired judges. You're dealing with seasoned realtors who have experience in navigating these issues, and will kind of defer to their own internal biases and past experiences when resolving those disputes.
And so with that, if they go through that process and like you said, they don't come to a conclusion, is that when it escalates?
Yeah. So when you go to mediation, uh, and mediation is a kind of a settlement tool where you have a neutral third party who um, who tries to resolve a dispute for you. He's there to, you pay him, he works for you as a neutral to try to get the case resolved. If that doesn't work, that's when you go to arbitration, and arbitration under the California Code of Ethics and Arbitration Manual is binding towards the brokers. And there is an appeals process, but it's very limited. So, if you don't get it resolved at mediation and you have to go to arbitration, that's when they decide, after hearing all the evidence, testimony from witnesses, and, usually the buyer and seller testify. Uh, that's when the arbitrator, or multiple, if there's a panel, will make a ruling and decide on the merits of the case. And then the brokers and realtors are bound by that decision.
So I know there's been a huge case that they just settled, a bunch of real estate companies, and some of these real estate companies, large companies, are not signing in with NAR. I mean, they're completely breaking off. Does that make these cases a little more difficult? I mean, because they basically are out of the NAR rules now.
Yeah. So that's interesting because, yeah, NAR has its own set of rules and
Mhm.
guidelines. And then under that you have CAR,
Right.
California Association of Realtors, that has its own rules and guidelines. And then under that, obviously, you have the local associations. Now, if you're not part of NAR, I'm I'm trying to. It's been a while since I looked at the NAR rules, but they're very similar to the CAR rules, from what I remember. And it's interesting that there's some companies breaking away from NAR. I don't know what the practical implications of that are,
Right.
but as far as dealing with procuring cause issues, dealing with the arbitration and mediation that brokers have to go through, that I believe more or less stays the same. As far as NAR goes, I know they give you resources, and they probably provide classes and guidelines for how to avoid procuring cause types issues.
Mhm.
But yeah, I'm not too sure of what they really do aside from providing these rules for associations to follow, at least in California, because we have CAR, and CAR is,
Right.
you know, uh, they got their own rules, and they're probably more restrictive than NAR actually. So you would
I
always
think so, yes.
usually defer to CAR. Yeah.
So basically, if you were to get into contract and you were an agent and you were under car, and this agent was not part of that, he wasn't a realtor, he was just a licensed agent under DRE, those kind of rules would apply basically, depending on
Yeah,
they agreed up on that contract, because they usually use a car form anyways.
yeah, they usually use a car form. But in short, both rules would apply.
Mhm.
Um, but the NAR, and I'm trying to think back to, because I read the rules about maybe a year ago last, and I know they're constantly updating them. But they're, from what I remember, they're less restrictive and than the car rules. So usually I would defer to what car says
Right.
when litigating these broker to broker procuring cause disputes. Um, and like you said, people use the car forms, which incorporate
That
the.
specifies the language in it, right?
Yeah,
Yeah.
yeah, and then just by essence of being a realtor in California, brokers and agents have submitted themselves to the jurisdiction of CAR and bound themselves by the California Rules of Ethics and Arbitration Manual. Um, so they've already agreed to be bound by those rules. I don't think that necessarily makes you bound by NAR, though. It kind of just depends on, like you said, if that brokerage had uh, pays the dues or whatever.
Right. Right. So, going with past the procuring phase, and now you're into contract. What are
Mhm.
some of the common uh, things that run by your desk as far as dealing when people are in contract?
Yeah, so let me deal with the procuring cause issue first.
Okay.
Um, the common procuring cause types of disputes that you see are usually dealing with uh, buyers and whether that agent was the procuring cause for that buyer to buy the property. And
Right.
you usually see it when there's an agent that's just representing the buyer, introduces them to the house, and then that client ends up going with somebody else to represent them in their
The same
purchase of that house.
transaction. Right.
Yeah, that's kind of the most common situation you see. Um, but once you get past that and you're looking at the common disputes between the the buyer and seller, they usually, you know, there's a wide gambit of disputes that you see, but typically you see non-disclosure issues, meaning a situation where the seller was under a duty to disclose a defect that materially affects the value and desirability of the property, and they fail to disclose that potential defect. Um, I always inform my agents that I represent to tell their clients to over disclose
Right.
and really cover yourself because um, something that might seem innocuous to you and maybe not a big deal would be a huge deal to a buyer. So don't trivialize matters. Don't use when you're disclosing certain defects. Don't use adjectives like don't say minor flood. Don't
These are
say
all personal
don't
opinions. Yeah, you
yeah, yeah,
just be
don't, yeah,
direct.
leave, yeah, exactly. Leave your opinions out of it,
Right.
and just kind of be objective. That's what I always tell them. Because yeah, the disputes over non-disclosure issues are a huge part of ways that these contracts can come back and bite you after close of escrow.
And that's usually, like you said, it's after the close of escrow, the new owners have moved in and they discovered this, that, and the other. And they decide to do some investigation into it and found that the problem has existed for a while, or that the seller, there's no way that the previous seller would have not known about it. And I
Yeah,
think that's the case, right?
yeah, absolutely. The hardest part about these cases is to prove that the seller knew about it. Sometimes it's not hard, sometimes it's easy. Sometimes there's you know, I've represented people on both sides of this equation. Um, there was a situation one time where I represented a buyer who bought a house, found in one of the drawers like a binder of the entire history of the house, like all the
Wow.
invoices, you know, that the seller had kept a hold of, regarding the maintenance and, you know, repairs on the house. And, you know, in the binder, there were several invoices regarding the exact same issue that the buyers were dealing with. That was never disclosed during the transaction. So then in that situation, they could easily prove that the seller knew about the defect and just didn't disclose it.
Right. It was just an ongoing issue, and
Mhm.
maybe the seller forgot about it when it was time to sell.
Forgot about it, or yeah, whatever happened, they just
Right.
didn't think it was. And you know, sometimes the sellers truly they don't know how to fill out the forms. It might be their first time filling
This
out
is
these,
also the case. Yes.
yeah, the transfer disclosure statement and seller property questionnaire, and they just don't know what to do. And they try to get advice from the agents, and the agents, you know, sometimes they don't give good advice, sometimes they do. It just depends on the type of agent.
Yeah, and I think that's a good point. Is that if you're representing a client and you have a seller, you should also tell them, hey, if you know about it, just disclose it. It's much better for you, your brokerage,
Mhm.
and the whole transaction in the whole part of it. You know.
Absolutely, because a lot of times the agents can get pulled into these disputes as
Right.
well.
Mm-hmm.
Because one of the ways a buyer can sue the seller's agent, even though there was no contractual relationship between the buyer and the seller's agent, is to show that the seller's agent knew about this defect and also didn't disclose it, because the, you know, the listing agent or the selling agent also has a duty to disclose those defects in the avid, and just in general.
So have you seen with these cases of non-disclosure that they will pull in a larger corporation or a larger company, like if they're the agent or the selling agent or listing agent? Is that the usual case when somebody decides to go ahead and move forward with a case like this?
It depends. You know, some people will just, by the very nature of the case, pull in as many people as they can.
Right.
You know, they'll pull in, they'll, you know, if they're representing the buyer, they'll, in this type of non-disclosure case, they'll pull in the, you know, their own agent, they'll pull in the seller, the seller's agent, they'll pull in the property inspector. It just kind of depends on the situation. I don't do that unless I have clear evidence that all those people uh, participated in some sort of wrongdoing. Um,
So I hear this um, is that some brokers say that if you have a very nice E&O policy, that you're going to be pulled into into that whole mess there. Is that really the case? Is that what lawyers look out for, or is that just like kind of hearsay?
I think, you know, I don't look out for that. There are some people who think if you have a big E&O policy, it makes you a bigger target.
Mhm.
I don't really subscribe to that mentality. Um, I try to be more altruistic, I guess, and I say, well, if you did something wrong, then you're going to be held accountable. But other than that, you know, you shouldn't. It shouldn't matter what type of insurance you have. And really, if it ends up going to trial, the information regarding insurance can't even come in, so it wouldn't matter.
This is true.
Um,
Yes.
yeah, but as far as, you know, having the ability to pay out, that's one of the factors that plaintiffs have to consider when they're bringing a lawsuit, because, you know, you could be dealing with the worst person in the world. If they don't have the ability to pay you, if you get a judgment, then what's the point of bringing this lawsuit? So
That's
as far as that's concerned, you know, yeah, an insurance policy can be um, uh, relevant to that analysis on the plaintiff side, but it shouldn't be.
So what about these cases for disclosing like properties such as trusts that are in a trust and or being sold by the trust, or properties in probate where there isn't really a whole lot of disclosure going on because the persons receiving the property don't really have much knowledge of that. How do you work those issues?
That's a really good question. And there's, you know, statutorily, there's an exception to, you know, probate sales, um, where they're not required to fill out the transfer disclosure statement or seller property questionnaire, one of those. Um, but, and it's a big but, they still have a common law duty to disclose anything they might know about the property. So even though there's no statutory duty, there still can be potential liability on the side of a probate sale if if the executor of the estate has some sort of knowledge about the house and doesn't disclose it. And those are really tough cases to prove, not impossible, but yeah, it's still something that they have to consider. So for instance, in a probate sale, if there's like a tenant in the property and that tenant is horrendous, that might be something that the probate estate has to disclose if as far as they know. um, and certainly would be something that the real estate agent would have to disclose representing the estate, because they probably know about the tenant as well.
The
um,
situation, right?
yeah, so and actually the fact that it's a probate sale doesn't affect the real estate agent's duty to disclose that.
Right.
That selling agent's duty is still the same. um, but yeah, obviously, in those types of situations and foreclosures as well, the seller doesn't have any knowledge of the property typically, so they have a very limited duty to ability to disclose.
So, as part of the disclosure during the process of this sale, usually an agent fills out an agent visual disclosure.
Yes.
So, as as being the person out there doing the actual inspection, if you will, what should we really be commenting on those sections? I mean, or in that report?
Yeah, that's a great question. A lot of the times I see realtors, their selling mentality kicks in and they'll use the Avid as a way to, market the property again, brand new carpets in living room, uh, brand new paint job. That's not what you disclose in the Avid. What you want to put in the Avid is any issues that you might see in the property. For instance, crack in the ceiling, um, crack in the tile, stuff like that. And again, you want to refrain from using modifiers. So instead of,
Major, minor crack.
yeah, never say minor cracks, right? Like, what are you, some sort of contractor? Do you
Right.
know what
Yes.
you know
Yes.
what that
It's a
you know
crack.
I
That's about
I
it.
see a yeah, I see a crack. I don't know if it's a crack in the paint or a crack in the, something structural. I can't tell the difference. So
Right.
um, you want to refrain from using modifiers like that and just kind of keep it simple, stick to the facts, but also, disclose what you know. You always want to disclose what you know, because if you don't, it could come back and bite you.
So there are some agents that also do contracting, or they may have a general contractor's license. Does that make them more liable than just your average agent?
Well, it certainly makes them more knowledgeable in certain situations, and and a lot of times, the clients like that. They want a real estate agent or a broker who has that additional experience as either a contractor. Sometimes there are lawyers who
Right.
are agents as well. And that's when you kind of see the duties getting a little gray. Um, you know, an agent as a uh, representative for buyers and sellers, they owe a fiduciary duty to their client, which is like the highest duty you can owe to a client. It's the duty to act with loyalty, care, and and I don't think that duty is affected whether or not somebody is a contractor or a lawyer as well. Um, you could certainly make an argument that uh, that if a agent was also a contractor and they didn't identify certain you know constructural defects with the house, that they might be liable. I think that might be kind of weak unless there was more information on that. If the agent was also hired to flip the property, because sometimes you see that too, or agents will be in some sort of relationship with investors, where
Or like
they'll,
the arm's length transaction where that comes into place.
yeah, so that's when stuff gets kind of gray, because as far as the real estate agent relationship goes, they're only representing you in the buy, purchase and sale transaction. But then once you get into, well, I'll also manage the flip and the renovations. Well, now, okay, so let's look at that. Now, is that real estate agent a fiduciary when it comes to managing the renovation? Is that part of his uh is that part of his real estate relationship when it comes to, the fiduciary duties he owes? That's when it gets a little bit more gray, and it really, there's no, one size fits all answer to that. It kind of really depends on the situation.
So usually there is a selling agent and the listing agent.
Yeah.
But if you're in the case where you just mentioned, if that agent represented both parties, which is basically like a dual agent, then
Mhm.
that's and there's something that comes up after that transaction is closed, then
Yeah.
that's more of a position where there may be some things where maybe some things were not disclosed.
Yeah,
Um,
that's when you see the most lawsuits, when there's a
right.
dual representation, dual agency. It's not banned, the car lobby is a strong lobby, and you know, they've not banned dual agency, but there is a uh, fine line that those agents have to walk when 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 doing that sort of transaction. So, for instance, they now owe a fiduciary duty to both the buyer and seller, and so what does that mean? If the agent knows that the seller is going to, take $900,000 on a property that's listed 1 million, is the agent supposed to tell his buyer client that? You know, I mean, you would think he would, because he owes a fiduciary duty to the buyer to get the best price for him, but then he also owes a fiduciary duty to the seller to get the best price for him. So, what does he do in that situation? The
So
the courts,
really, if you're a dual agent, you're really limiting that fiduciary duty to each party, because there's no way you
yeah,
can really do both and walk that fine. I mean, there is, because it's allowed, but
yeah,
it's just implied. There's just no way you're going to be able to do that.
yeah. At the very least, you want to get different agents, even though it's the same brokerage. You want to get different agents to represent each party.
Okay.
Um,
Mhm.
but still, it's a precarious situation, because at the end of the day, the broker is the responsible party.
Right.
The agents are agents for the broker, and they're treated as essentially the same person under the law. Um, so you want to try to limit your liability by getting at least two agents, but that, at the end of the day, if you kind of step off and you don't walk that fine line perfectly, then there could be some issues.
Right. So disclose as much as possible
Yeah, and also
in
disclosure
any situation.
in any situation, but especially when you're dealing with a dual agency situation, you want to be extra careful.
Um, so as far as those issues with disclosure, and what does the litigation look like? I mean, is that is that the same mediation process? How do we resolve these issues?
Good question. So every car form has that mediation provision in there,
Mhm.
where any disputes between a buyer and seller have to go to mediation. There are certain exceptions where there might be a small claims action or an eviction action or a foreclosure, but any other dispute has to go through mediation first. And there's a process for which you can select the mediator. Usually, I think the forms say you can go with somebody in the real estate REMC, but you don't have to. As long as the buyer and seller agree on a mediator, they can pick that mediator. Um, Now, what are the consequences if you file a lawsuit without or without going to mediation, or you refuse to go to mediation? Well, the car forms say in that situation, if there is a lawsuit filed, the prevailing party um, would not get their attorney's fees if they were the party that refused to go to mediation. So there is a prevailing parties attorney's fees clause in the RPA. If you refuse to go to mediation, or you fail to demand mediation prior to filing a lawsuit, you risk losing your right to prevailing party's attorney's fees if you are the prevailing party, for instance. So it's a big deal. You really want to go to mediation, because if you don't, that's a, you know, you don't want to risk that that significant cost. Um, if mediation doesn't resolve the dispute, then there's an arbitration provision in the RPA too, and you have to, the buyer and seller have to check the box for arbitration in order for the case, in order for that arbitration provision to apply. But as well as I do, in the age of DocuSign, you literally can't uncheck the arbitration box. It won't let you move forward. So you have to check everything to even be able to move forward in the
Yeah, that
DocuSign
is a
process.
software system. I know exactly what you're talking about. Yes.
Yeah.
Uh,
And
um,
sometimes you can just auto click everything and it'll just boop, boop, boop. So, it'll initial
yeah,
everywhere you need to initial.
yeah, and this is why it's so important that anytime you send a digital signing document, to make sure to go over it still with your client.
Absolutely.
So because you want to make sure that they're clear with every single piece of every paragraph that's there if they have any questions, because ultimately it is you're the person delivering that contract to them, and they're not going to they're going to take your advice, but really they have to make their own decisions as far as they want to accept those terms.
Yeah, yeah, absolutely. And a lot of times a realtor will get a question from their client, hey, what's this arbitration provision? What does it mean? Like, what is that about? And you find yourself in a rock and a hard place, because, well, you can't really give legal advice. You're not a lawyer. Do you even, sometimes agents don't even really know what arbitration is. They haven't gone through the process, so they can't really explain it. So what advice do you give to your client in that situation? I've always told my realtors in the past, have a lawyer in your speed dial. Have three lawyers in your speed dial. So in those types of situations, you can have a friend that your clients can call that can explain that to them. And I'm always able to do that for the agents that I represent. Um,
And that's a really good tool and a really good way to manage those situations. I always
yeah,
tell my clients, I read the whole mediation paragraph, so it's like I'm just reading what it says. That's it.
yeah, and that's all you can do. That's all
And
you can
that's
do.
all you can do, right?
Yeah, and there are, oh God, there's so many car forms that, it took me a while before I even realized this, but there's, the advisory forms, which give even further
Oh
detail
wow.
as to
Yeah.
what the arbitration and mediation provisions mean. So, direct them to I think it's a statewide
The
buyer
statewide
and seller advice.
advisory. Yeah.
Yeah, yeah,
Mhm.
that's the one where it has even more detail
Right.
on those provisions. And,
Well,
CAR made a revision, I think it was in 2021, to the forms, where now, buyers and sellers don't have to look past the first, one or two pages, because that's where all the material terms are now. They put everything in the first couple pages, which is, it's nice, because now, you have to read the whole thing, but you still have to read the whole thing. So
it
they kind
still
of made it
highlights.
easier.
Yeah.
Yeah, they kind of made it easier for people to ignore the rest of the contract by putting every material term in the first,
It's almost what
two
they did
pages.
with the purchase contract, where they put all the pertinent information in the first 2 pages rather than going through the whole contract.
Yeah,
So
yeah,
it makes it a lot easier to navigate. I mean, I agree with that, but nobody ever goes, well, you're supposed to go back and read what those sections are.
yeah,
Until we find ourselves into a situation, and then we go back and read those sections. And that's not where we want to be. We want to handle it right up front before
yeah,
anything gets out. Mhm.
yeah. But at the same time, uh, some people don't know that the car forms can be changed. They can be revised. You could
Yes.
throw in an addendum to change certain sections if you don't like it. You obviously have to get the other side to agree, but if you're, that's what the whole it's a negotiation, right?
Right.
So there's some give and take. There always is.
Terms, yes.
Uh, yeah. So it's important to read the whole contract in the beginning, but I'm not surprised when people don't.
So I want to move a little past this, and let's talk about damages. Now, there's
Mm.
there's the EMD, right, which is the earnest money
Yeah.
deposit that the escrow holds, and
Yeah.
then there's certain damages that are maximum damages. Is that limited to that EMD 3%? There's a lot of noise out there, but I don't really have like a clear answer on that. How do you determine damages?
So it depends on the situation. The EMD comes into play when there's a falling out in the escrow process before there's a closing.
Right.
And that usually uh, involves the seller, or I'm sorry, the buyer backing out after they've waived all their contingencies, and the contract goes hard, so to speak. Once that happens, there's enough gray area where there's always an argument to be made on behalf of the seller that I deserve my deposit back. Maybe the I'm sorry, where the buyer deserves their deposit back. There's always a situation where, maybe the seller failed to disclose something or didn't make a repair they said they were going to make, and you just discover it on the last day. Stuff like that. And in that situation, depending on how much is in the deposit, you go to mediation, you potentially go to arbitration. Um, Obviously, if the deposit, that 3%, is not that much, which nowadays it usually is quite a nice chunk of money, given
The properties in the 800,000 range, yes.
yeah, absolutely. And when I was in San Diego, it was hard to find a property under $1 million. So, when you're dealing with those types of EMDs, parties are going to pay for mediation to resolve that dispute. They're not, buyers aren't willing to just give up that money. They never are. There's going to be a mediation process. And then in those situations, you assess the arguments of each side, and you come to some sort of a resolution, um, because the last thing a seller wants is to tie up this property while they're disputing over this EMD and not being able to sell it to somebody else. And the last thing the buyer wants is their money tied up in escrow for God knows how long. So usually there's a resolution made. Not always, but usually there is.
If not mediation, and you go through all the steps and try to resolve that way.
Yeah. Yeah,
So
because escrow won't release that money unless they have, and this, they won't release that money until they have a signed agreement from both parties telling them where to put it.
yes, there's only two things that are going to release it: either a mutual agreement or a court document. And that's about
Yeah.
it.
Yeah. Yep. Absolutely.
And so, we're going to come to an end in our discussion here. But is there any questions, if you do have, for Nicholas? If you could raise your hand or put it in the chat box, I'll give you guys a couple of moments to put that together. Well, Nicholas, I think you were very, very vocal, and I think everybody really got some good information. They don't have any questions, but how do people reach you? How do people contact you?
Yeah, just Google me, Nicholas Kritikos. You could look up my website, kritikoslawfirm.com, and all my contact information is on there. I'm located in downtown Upland, so I'm pretty central to the IE. And I mostly practice in, I also have an office in San Diego. So I mostly practice in, San Bernardino, Riverside, and San Diego County.
That's excellent. And then you're right on the border of LA County also. I don't know if you get involved in LA County, but
I do get involved in LA County.
fantastic.
Yeah, I try to stay away from LA County, but I'm always for whatever reason drawn out there. So yeah, I also do LA County.
All right. Well, cool. Well, thank you so much. This has been very informative. I really love the responses that you gave. I think we got a lot of clear information, and definitely we're gonna this is a recording, and we're gonna post this on our site. It'll be up in maybe about 24 hours. So if anyone missed any part of it, they can go back and start from the beginning. But thank you so much, Nicholas Kritikos, and have a great day. And if there's anything that you want to get Nicholas's information, reach out to him on his website. Thank you.
Yeah, check out my website. I'm always willing to hop on the phone for 5, 10, 15 minutes to go over any issues you might have.
Thank you.
Thank you.
Have a great
Take
day.
care.